Global happenings today. We communicate, we analyze global news. Stay tuned.
Hello, beautiful people. Welcome back to Global Happenings Today YouTube channel. Yes, we are live in court, and PDP's matter for today is over. Of course, right now it's now the time for Labour Party, and fortunately and most shockingly is the fact that both Peter Obi and Yusuf Datti, the vice presidential flag bearer of the Labour Party, and Chimamanda are all live in the courtroom. Of course, the legal team of the LP is here. Abure is also ably seated. The justices have also arrived, and of course, for those representing Peter Obi, Dr. Liva Ozoku's son is also leading the legal team today. Peter Obi is standing in for the petitioners. Mr. Oseloka Obaze, Barrister Julius Sabore, Chief Akin Osuntokun, all of them are present in courtroom today. And it's quite unusual today. The court is filled to the capacity. The lead counsel to INEC, A.B. Mahmood, Senior Advocate of Nigeria, announced his appearance alongside with his learned colleagues. Chief Wale Olanikpekun is also announcing his appearance. With him are other members of Alta and Inaba, which are Senior Advocates of Nigerians and non-Senior Advocates of Nigerians. Of course, Chief Lateef Fagbemi, Senior Advocate of Nigeria, also announced for APC with others, sans and non-sans. The matter slated for today has been mentioned as adoption of final written addresses by parties. That of Atiku and the PDP was done from 9 a.m. till about 12:15 p.m. thereabout earlier today. And of course, the court has begun. The court said we will begin with the objections before we come to the main written addresses. A.B. Mahmood. A.B. Mahmood now said this case is different from the earlier case because the petitioners here have also raised objections. Of course, Chief Levi Ozoku also now said we prefer for them to start. Then A.B. Mahmood now began. A.B. Mahmood now said, my learned friend Stephen Edehe will lead the procedure. Now Steve Edehe now began. He said for quick response, Steve Edehe is actually signed for INEC. So Stephen Edehe now began. So the first respondents, which is INEC, objections on admissibility of documents in evidence was filed on 14th of July 2023. We also filed a reply on point of law on the 28th of July 2023. We adopt the content of the said written address. Court now said indicates there's an error. Edehe now said, well, we seek leave to correct that line. Read seats to read which do not have. Court now said correction done. Steve Edehe now continued, said, thank you, my lord. I adopt the same processes as our argument before this honorable court to sustain the objections. Now, court now said, Chief Olanikpekun now said, my learned brother Yusuf Ali will conduct the. Now, for Yusuf Ali, that's Senior Advocate of Nigeria's son for both Bola Ahmed Tinubu and Shettima, said the argument on objections of the admissibility of the document was articulated and filed on the 14th day of July 2023 upon receipt of the reply of the petitioners, which is Labour Party and Obi. It became imperative to file a reply on point of law, which we did on 25th of July 2023. We adopt these proceedings in urging my noble lords to sustain the objections and strike out the inferred document before my noble lords. Now, L.O. Fagbemi, Senior Advocate of Nigeria for INEC now said, we filed our own written address in respect of the objections filed on the 14th day of July 2023. We also filed a reply on point of law on receipt of the petitioner's reply address dated 27 July, but filed on the 28th of July. We adopt our argument to reject our discountenance those documents. Now, Dr. Levi now said, our Kalu, Senior Advocate of Nigeria, will respond to the processes of the first respondent if it pleases my lord. Now, our Kalu now came up, which is for Labour Party, said the petitioners have the two processes in response. The first is the reply to the first respondent, which is INEC. It was filed on the 23rd of July 2023 against the first respondent objection filed on the 14th of July. I adopt the said process as our argument. The petitioners' reply to the objection raised by the second and the third respondent, which is Bola Ahmed Tinubu and Shettima, was filed on the 20th of July 2023. 2023. In respect to the objection by the third respondent, which is Shetima, the petitioner's reply was filed on the 23rd of July 2023. We adopt the petitioner's reply to all the respective parties. And Dr. Levi now said Chief Anechebe, Senior Advocate of Nigeria, will also take charge of our own objections. Now, Chief Anechebe, Senior Advocate of Nigeria, signed for Labour Party, and I said, may it please my lord, my noble lords, the objections against document tendered by the first respondent, which is INEC, was captured in our written address dated 22nd July, but filed on the 23rd of July 2023. There was also an objection filed against document tendered by the second and the third respondent, Bola Ahmed Tinubu Shetima, filed 20th of July 2023. We respectfully adopt the argument canvassed in the two processes in the opposition to documents tendered by the first, second, and third respondents and third objections. They are our admissions in urging your lordships to expunge the said document from your bundle of documents and sustain our objections thereto. Now, Stephen Edehe for INEC now said, in opposition to the petitioner's objection on document, we filed a document on the 20th day of July 2023. We adopt the content of the said written address to overrule the objections. Now, the court gave the parties 20 minutes each for their oral submissions The court gave the parties 20 minutes each for their oral submissions proper on their final written addresses. There is a timekeeper who rings the bell which indicates once the period allotted to each party is exhausted. So it feels like some sort of being in school again. Now, Yusuf Ali for INEC now said that in reaction to the petitioner's objection on document, we filed a written address which was filed on the 25th of July 2023 in opposition. We adopt the argument in the document as our argument, especially as there was no further reply by the petitioners. Now, L.O. Fagbemi for APC now said, in respect to this objection, we have no processes filed. Now, court now said, we will now go to the main addresses. Instead of 10 minutes, parties should be allowed and allocated 20 minutes each to address the court. Now, A.B. Mahmoud for INEC now said, the first respondent has filed the final written address dated on the 14th day of July 2023. Along with that, we also filed a list of authority, also dated and filed 14th day of July 2023. After I received the petitioner's written address, we also filed on reply on point of law, filed to the 8th of July 2023. We also filed a list of authorities on the same to the 8th of July 2023. These are the processes filed by the first respondent. We adopt same as our argument in this petition. My lord, for all the detailed arguments covered in our written address, we humbly submit that this petition is lacking in merit and should be dismissed by the court. I will seek the lordship's indulgence. On page 15th of our written address, we set out the issues for determination. They are listed. I will only speak to two issues. The first issue is issue number B, has to do with the complaints by the petitioner of non-compliance with the provision of the Electoral Act. This essence of the complaint is with technology introduced by the first respondent. The rationale seemed to be appreciated by the petitioners. However, the misunderstanding the technologies, the BVAS was used for accreditation and transmitting of results. The RF portal is a result viewing portal. The evidence shows clearly that the first respondent went to great lengths to ensure that this technology functioned as designed. The applications used on BVAS used on BVAS was developed in-house, tested for performance and vulnerability. Data was also hosted on Amazon Web Services, and evidence shows it was most advanced and secured web service provider in the world. The intention of the first respondent was beyond doubt, both for the petitioner and on ourselves. The petitioners have contrived in their minds the so-called electronic collation system, which was prescribed by the first respondent, which they have brought no evidence to show. Although the petitioners consistently argued that the National Assembly and presidential elections went on concurrently, but they never showed there was any electronic collation of results in the National Assembly or any other election. What was in place was the manual collation. Now, the second is the response to the glitch This glitch was orchestrated by human beings to alter the result. The case put forward by the first responder is that the glitch didn't occur by human effort but by normal function. My submission was that if there was a human interference on the machines, the petitioners ought to have shown it. If they failed, the argument fails. Also, the IRF portal was for the public view and did not affect the result collation. It was only for trust. All the witnesses have agreed on this. All the argument of AWS being faulty or not result is a no issue. There has been argument about 18,088 so-called blood polling unit result on IRF. My argument is that this goes to no issue, as those blood results did not in any way suggest that the original copies of the result sheets were also blood. They have not tendered the original copies, which are in the possession of their agents. That complaint of blood results are simply for dramatization. From the state of evidence and from the state of all the pleadings before your lordship, which interrupted the transmission for over 4 hours, did not impart the results, and there was no evidence that there was any manipulation of results. Now, moving to the second point in relation to the 25%, I will first of all day that there is no dispute as to fact. The only issue is in relation to the interpretation of the relevant aspect of the Constitution in Section 134, which says the candidate must score 25% in 2/3 of the state and FCT. Your lordship should not adopt an approach that will result in an absurdity, which the voters in FCT are ascribed superior position than the other voters. We hereby submit our argument. Haba. Now, Wole Olanipeku now said the second and the third respondent filed the final written address on 14 July 2023. Also, on receipt of the process filed by the petitioners, a reply on the 21st July was filed. We also filed a list of additional authorities on the 31st July 2023. We also adopt these processes in arguing your lordship to dismiss this petition. We also urge that it is a gross abuse of processes of court. I will draw your lordship's attention to a process filed by the petitioners that the petitioners have no final written address. The petitioners' argument is in response to the second and the third respondent are not acceptable, and we seek my lords to discountenance this document. I will address a few areas. One is about non-compliance, that the results were not uploaded in real time. Upload to IRF is not part of the collation process for the purpose of declaration of results, as all collations are done physically at the respective polling units and collation centers where results are entered at the appropriate INEC locations. May I refer your lordship to Exhibit X1, which is a judgment of Superior Court order given at the instant of the second petitioner that the court should declare that INEC should declare result electronically, and judgment was given. The second petitioner, which is Labour Party, also went to a high court in Lagos and obtained a contrary judgment. The Court of Appeal squashed that judgment, stating that Exhibit X1 squashed Section 137 subsection 1D of the Constitution. The issue does not arise at all. It says he is under a sentence of death. It is a present tense, not that he was, but that he is presently under. May I draw your lordship's attention to subsection E, that he's sentenced in a period within 10 years. In primary school, we were taught present tense and present participle. The second respondent is not under any fine. The argument in respect of the FCT, let me read the provisions of the Constitution. Section 134 subsection 2, may I make this submission on vended needs that what the Constitution is talking about is votes scored, not landmass, and that was what the Supreme Court emphasized in the case of Awolowo versus Shagari. The second respondent scored more than 1/4 of 1/4 of the votes scored, and the FCT and the first petitioner, with all respect, has no local standing to question the 25% outcome of the decision, as the Constitution forbids him to contest in a re-election if such were to be the case. Lastly, is the question of the first petitioner breaching the law. We tendered Exhibit RA18 gave evidence that he was not a member of the Labour Party. You cannot benefit from your own wrongdoing. There is no connectivity between the petition and the reliefs and the parties. May I urge my noble lords to dismiss this petition and urge my lordship to do hold on my bended knees. Now, LO Fagbemi, which is the fourth respondent for APC, the fourth respondent filed a written address dated and filed on the 14th day of July 2023. There's also the fourth respondent reply on the point of law, which is dated on the 27th day by file. The 27th day was filed on the 28th day of July 2023. Respectfully, I adopt and rely on these two processes. I urge the court to dismiss this petition. I will adopt the oral submissions of my AB Mahmood and our leader, Chief Wole Olanikwe-Kunsan. I have refrained myself, but I have to be mild to say that this petition is ambiguous. The second petitioner has abused the processes. They suffered defeat in Abuja and ran to Lagos. They had a short victory as the Court of Appeal shows the results were disastrous. Unless there is an appeal to overrun the decision of that court, this procedure here is a gross abuse of process. The investigation is in an election is to seek whether voting took place, the result declared and collation. I will give it to them where they have done well, and that's that they did not dispute the voting. Counting, collation, and results are the important things. The one at the unit level is the most important. If anyone wants to attack the results, there has to be a polling unit by polling unit allegation and proof. If they are contending that there were contentions with the transmission, it has to be polling unit by polling unit proof, which was really also lacking. It is a question of, before you go RF, you must start low ref. The much touted issue of rerun is a two-horse race between the two leading contenders, vote-wise, which does not concern the petitioners. Section 134, subsection 3 of the Constitution also buttresses this point. Even if you want to do this, your lordship will ask, where was the man who came second? It is one of the reasons why we will describe this as a meddlesome interlopers. Disqualification means anybody is qualified except it suffers under the provision of Section 137, subsection D of the Constitution. It is not a criminal forfeiture. There was no charge, no trial, no conviction, so Exhibit BA is devoid of the requirement. PW1 in this regard admitted that, strictly speaking, there was no defendant for any criminal offense under cross-examination. In any event, evidence abhors that there was clearance given to the second respondent, a clean bill of health. The question of the status of FCT does not enjoy any special status as far as elections are concerned, especially presidential election. The second respondent scored more than 25% in about 29 states. That suffices, and to do otherwise will amount to constitutional absurdity. On the issue of IREF, there is no point that there has not been decided. The case has been settled by the decision of the Supreme Court in SE/C4/508/2023. It is reported in Oyetola vs. INEC 2023 11 NWLR Pete 1894. This has cleared any doubt in the air as to the position of INEC, whether it's adequately conducted the election. No one is perfect, and INEC scored at least 90% in this election. All right, these are all objections raised and all that for both APC, INEC, Bola Ahmed Tinubu and Shetima. Labour Party legal team have not started their own. No. So we're going to take a break. Of course, when we come back, we'll give you exactly as it's happening in real time. It's happening now as we speak. They are not concluded yet. Though we started late enough reporting, but they're still on interest. So we're going to give you report online real time as Peter Obi legal team begins their own fireworks. Let's go wrap it up. Let's put in our conversation. What's to take. Have a nice day.